Well, good afternoon, everyone. We are very excited to have you join us for a Texas CASA moderated panel on effective CASA advocacy in a virtual environment. I am your moderator, Rob Hoffman, judge of the 452nd Judicial District Court of Texas, and also a jurist in residence for the Texas Children's Commission. We hope to give you good advice on what to do before, during, and after your CPS hearing. And we may even mention a few silver linings about how Zoom is making things better in the CPS realm. Please note that questions will be taken at the end of the webcast and that we will attempt to respond to all of the unanswered questions via email following the webcast as long as they were not submitted anonymously. Special thanks today to the Texas Children's Commission, who had a similar panel, which we moderated back on May 22nd, upon which this webcast is based. Now, we do have four wonderful panelists here with us today. Anne-Marie Smith is an attorney with many years of experience representing both children and parents in CPS cases in South Central Texas. Dennis Arriaga is the managing attorney for DPS in Region 8 and is board certified in child welfare law by the Texas Board of Legal Specialization. Leanne Lopez is the senior advocacy coordinator with CASA of the South Plains in Lubbock. She's been with CASA for over 4 years. And Terry Fott has been a volunteer advocate with CASA of the South Plains for 2 years. We're going to begin by spending a few minutes to talk about how to get ready for a virtual hearing. We're going to start with some simple questions about dress code. Leanne, start us off by telling us what you tell your advocates to wear in court.
I tell my advocates to go ahead and dress as if we were still going to court in person. Make sure you try to remain as professional as possible with your dress. Even though we are doing these via Zoom, and our judges here in our region have specifically asked of not just CASA, but every party to go ahead and dress as if you were still coming into the courtroom.
Thanks, Leanne. Well, Anne-Marie, what do you tell your clients about their appearance in virtual hearings?
So, Judge, I tell my clients that appearances matter, and that a judge could deem it offensive if they're not addressed appropriately. So I tell them to dress as if they're actually in the courtroom. No bathrobes, no pajamas, no towels wrapped around their hair. They should be presentable and professional.
Well, I've already heard this week about a person who appeared in court with a towel wrapped around their head. So we know that some clothing options definitely could be distracting, but there are other distractions as well. Anne-Marie, what other advice do you have for your parents and even for children that you represent about appearing in virtual hearings?
Yes, Judge. And so with respect to the parents, I caution them again to be mindful of their physical background, such as clutter, untidiness, remembering that they are also trying to impress the judge, that they have a clean and safe home for the children to come home to. And so also no barking dogs, no birds chirping, music, television, radio, eating, drinking, chewing gum, things like that. Don't go to the refrigerator to get food or a drink. No one else should be present or speaking during the hearing. No chiming in, from other persons. In fact, no other persons should be with them during the hearing. And I remind them to keep their phone on mute unless they're speaking, to be on time, because there are some judges who will not allow them in once the hearing has started. In some judge, I just tell them to address the court only when it's their turn. When the judge's mouth opens, theirs close. No facial expressions, smirking, laughing, rolling eyes, outbursts, answering when somebody else's turn has come up. So, just the practical things on how to make a good presentation and impress the judge while the hearing is going on.
Well, Terry, as an advocate, what do you tell your kids that are appearing virtually about their appearance and their behavior at the hearings?
Judge, what I normally do is visit with my child either the night before the day of court and remind her that she needs to be in a quiet room with no distractions, no people walking through, maybe in a room where she can close the door and not allow any outside noise to come in. Also to dress appropriately, no t-shirts or that have sayings on them that might be distracting, no posters on the wall that might be inappropriate, and to also make sure that cell phones turned off, that even completely turned off, not where you can even hear it vibrate, and to also pay close attention and no distractions, and to be respectful.
Good. Well, Leanne, as a supervisor, do you have discussions with your volunteers about having to wait in the waiting room? What do you tell them?
I do. I refer to the waiting room as essentially the seating area in the actual courtroom. I tell them once they log into the Zoom hearing, we will be placed in the waiting room. I've had some that get kind of nervous of, I'm in the waiting room, I haven't been brought in. How does the judge know which case that I go to? I reassure them that all of our judges already know, our leadership program has let them know which coordinator, which advocate goes to which cases. And they also look at the court report. Our judges are really big about making sure and reading our court report, all those fine details that go into there. So they do notice that information of which CASA coordinator and which advocate go to those cases.
Well, we talked about it a little bit, but with folks in and out of our houses, how do you deal with that with your volunteers as far as confidentiality surrounding our cases?
I let them know that we still need to maintain confidentiality for our families and our kids that we're working with. And it can get, just a little bit trickier now that we're home. I encourage them to find a quiet space, whether it's a different room, if you've got to find a closet to go into for the hearing, just somewhere where they can sit and kind of focus solely on their hearing as well. I've encouraged some if they've got earbuds or headphones, that I think also helps kind of alleviate any distractions or background noise that may still be happening in the background.
Speaking of backgrounds, Texas CASA has some pretty cool Zoom backgrounds for us. Have y'all been using those?
Yes, our program here in Lubbock actually created some backgrounds for staff and for our advocates if they would like to use those. I unfortunately haven't been able to use a super cool background because my computer will not let me. So I do let them know if that's something they want to utilize. They can definitely do that. But I do kind of let them know that with those backgrounds, sometimes it can get a little tricky because if you move a certain way, then it can almost make it look like maybe your arm got cut off. So I kind of just warn them about moving consistently if they're going to use a background.
Right. Well, Dennis, I've had at least one CPS caseworker appear on a Zoom hearing in their car, but I think it was appropriate. They were doing something important and traveling. What advice do you have for your workers about virtual hearings?
The virtual hearings, they need to treat them, as I think all the other panelists have stated, treat it just like it's court. The backgrounds do matter. What you're doing does matter. How you're presenting yourself does matter. It reflects upon the professionalism of the department, the professionalism of the person involved, the specific caseworker. And, it along those lines, a judge is going to be listening specifically to the workers in these cases and other individuals. And so if you're having other distractions, other events occurring, it just doesn't show that you're devoted to that hearing.
We've talked a lot about facial expressions and how up close and personal we are with each other. Terry, what advice do you have about having neutral face expressions during our hearings?
I tell my child that, especially on Zoom, because your face is up close, and if something happens in the courtroom that upsets you or that makes you mad, makes you feel like you need to cry, even, to just please keep those emotions in check and try to be as professional and to always be respectful of the others around you, and to always pay attention to the speakers, the ones that speak before you. You need to be able to answer questions, and to, of course, always just try not to use emotions that are going to distract others in the courtroom or on Zoom.
Well, anecdotally, we hear that attorneys and our advocates all are spending a lot more time preparing before the day of hearing. Dennis, can you tell us a little bit about that?
Yes, since we've been using the Zoom hearings, there have been extensive efforts put in on the front end of our cases. There's a lot of communication that's occurring beforehand, and I think communication is key. With the Zoom hearings, we're trying to limit the time that's necessary for each hearing, and trying to streamline the process. So basically, the attorneys with the department have reached out to the parties in the case. They're trying to see if they can reach any agreements, seeing if they can limit the issues if they can agree partially but not completely, getting orders signed, just having orders reviewed. There's a lot of communication for case direction now that there's Zoom hearings.
Well, Anne-Marie, prior to Zoom hearings, a lot of that work got done in the hall before the hearing started. How are you dealing with the fact that we don't have those hallway discussions anymore?
So, Judge, as Dennis indicated, preparation and communication are key. We have to make sure that as lawyers, we're in constant communication with our clients, with opposing counsels, caseworkers, and of course, our CASA advocates before the hearings. And, that is, of course, to ensure that the hearings are run smoothly and efficiently. I stay in touch with my clients via text throughout the hearings to make sure that, he or she understands what's going on. If they have questions or concerns, preparing ahead of time, though, is key. And that includes communication, which includes returning phone calls, answering texts, answering emails, speaking with clients well before the hearing, and again, preparing for the hearing.
Leanne, it seems like initially we heard that all of our hearings were taking about 50% longer than they would have if they'd been in court. I don't know if that's changed as courts have become more efficient in their time. What's your experience been?
I definitely believe in the beginning they were taking a little bit longer, and I feel like a lot of that had to do with people just getting familiar with Zoom, what that process looked like, maybe working out technology issues that I think we all come across, of course, right when we're about to start the Zoom hearings. And I think just trying to figure out how to have those hallway conversations. I've seen our judges utilize the breakout session rooms as essentially the hallway. I think now that we've been doing this for several months, everyone kind of knows this is what the waiting room is. If you need to utilize the breakout rooms, you can just ask the judge to do that. So I think they are moving along more quickly now via the Zoom.
Well, do you think there's a particular type of hearing that's taking longer than any others because of Zoom, maybe an adversary hearing or hearings such as that?
I believe adversary hearings, final hearings that I think in general, whether would be in the courtroom or just via Zoom, sometimes those do take a little bit longer. I think we've all come across to where we think we've got an agreement for court that day, kind of get there and things have completely changed. So I think we still do come across some of those situations.
Well, Dennis, you touched on it a little bit earlier, but what exactly, agreement-wise, what do you try to get done before the day of hearing? Do you try to get more stipulations? What are you agreeing to?
Yeah, anything that we can come to a consensus on. It depends on the hearing. If it's an adversary or a trial on the merits, you're trying to see if there's an agreement as to the resolution of the case, seeing if there's an agreement for the admission of certain exhibits, exchanging exhibits so that everybody has them. If there's a partial agreement and you can narrow the issues, then let's do that to preserve time and resources. If it's other types of hearings like a status hearing, you might be trying to work out an agreement as to the compliance that each of the parents have demonstrated in the case, agreements for home study of a particular individual, visitation, those sort of terms. If you can reach an agreement on those kinds of issues, then it limits the issues and the testimony that has to be presented to the court.
Well, do you think that you're learning efficiencies using virtual hearings that you can take back with you after we get back to the courtroom?
Absolutely. And these are probably things that we should have been doing before as attorneys, but yes, it just goes to show that if you put that effort and the resources in at the front end, that the hearings don't have to be these long, drawn-out hearings, and they don't necessarily, I understand it's an adversarial process, but sometimes some cases don't need to be adversarial.
Well, to follow up on that, Terry, specifically as a volunteer, what do you do to be more efficient and prepare everything to get ready for your virtual hearing?
Most of the time we know a lot of what's going to happen in court on that particular day, but sometimes there are things that happen. So I always try to get in contact with the attorneys, with the therapist, with the caseworkers a few days before the actual hearing to see if there have been any changes since we turned the court report into the judge. And if there are any changes, I make sure that my child knows that there were some changes happen and what might be coming up in court, so that child is prepared. Even in court or on Zoom, I feel like it's important that the child be specifically prepared for what exactly is going to happen, so there are no surprises for the child.
That's a good segue for us to talk about specifically how to prepare children and even parents for the hearing. Anne-Marie, why don't you start us off? What do you tell parents about the process?
I tell parents that, Zoom hearings are no different than being in court, except in many cases, probably better, because they are in a more comfortable environment, comfortable space. They don't have to be nervous or worried about seeing someone they don't want to see. And so typically we do a run through, of what's going to happen. We discuss the questions, the issues that may come up, how they would answer a particular question or issue. And if a parent tells me that they want to address the court, I want to know what they want to talk about, because a lot of times they want to say things that aren't necessarily good for their case. So we want to talk about those things and talk about why do you think that's better, or why do you think that's something that the court needs to know. Usually I have the last word on that. But, I tell them if we didn't discuss it ahead of time, don't say it. And then with kids, we've already talked about, appearances, things like that. But I want to hear from the kid, what's important to you for the court to know? What is it that you want to discuss with the court? How do you plan to advocate for yourself? If there's going to be a meeting with the court, let's do a run through on what it is that you're going to be asking the court and how we can say something that may be more effective, things like that, clean language. But it's important for me to make sure that the child is heard and knows that he or she is being heard.
You talked about practicing a little bit. Is it a good idea to actually have a Zoom practice hearing with your kids and even your parents prior to the day of court?
It is. It takes away the unknown. So they pretty much know what to expect. And, we talk about the fact that it's a little bit different. The setup is going to be a little bit different because you're not in the actual courtroom. But here's the run through. Here's what's going to happen. You don't speak out of turn. I pretend I'm the judge, or I may be the prosecutor. I'm going to be asking you some questions. How are you going to answer? Things like that. And we talk about, of course, expressions and, facial expressions, credibility, things like that.
We're seeing parents in their own environment, up close and personal again. It seems in a way like the stakes might be higher for parents in Zoom hearings. Do you talk to them about that, Anne-Marie?
And so, Judge, the stakes don't necessarily change for parents because the same risks exist, and that is termination of their parental rights. But in a Zoom hearing, without thorough preparation, it could make effective representation more difficult, thereby, of course, increasing the risks to the parents. So again, I forewarn my clients about the do's and don'ts of the judge, to not have others present during the hearings, that they're under oath. If a parent has a criminal charge arising out of the CPS case, or perhaps, a pending case, pending charges, we discuss Fifth Amendment privileges, what not to discuss, when to invoke, what the privilege is. And finally, I remind them that the judge and the child's ad litem are always judging their credibility. So to be mindful of that, to try to appear on Zoom by video, if at all possible, because that's the best way to judge credibility. It's harder for the court to judge credibility over the telephone. So those are the kinds of things that we talk about. And of course, we again reiterate appearances and just following the judge's rules to a T, being on time.
Well, there's some other admonishments, and it seems like to me, I've had a lot of parents have documents in their presence or actually get up and go get something and bring it back and want to read it. What do you tell them about reading from papers that they have at their house?
Well, if we have prepared, they know what's coming out. They know it's their case. It's their service plan. They know what they have or have not done. And if they're reading from it, from a piece of paper, the judge may think it's scripted. And I myself have called people out, not my clients, but I will say, Your Honor, I think the person is reading could I voir dire that person? I don't want that to happen to my client. So again, it's the preparation, understanding that this is your client, this is your case. You know what's going on. You don't have to read. If we prepare, if we run through, you will be fine. And of course, nobody else should be in that room. They're under oath. And if you're caught, what the consequences could be to that.
Well, I had a hearing recently where I had the foster parents together on their couch, and every once in a while, the 2-year-old foster child would run through the room, jump in their lap, crawl over the foster dad. That was appropriate because they were 2, but Terry, that might not be appropriate for someone who's 12 or 16. How do you talk to your kids that are in care that are so familiar and comfortable with technology about trying to respect those boundaries and not getting too informal at our hearings?
Well, I just tell my child that even though you're in an environment that you're very comfortable in and you're relaxed in, that you are still in court, and that it's very important that you're appropriate, you're respectful, you listen to all the speakers, you pay attention to what they're saying, you don't speak out. The judge will tell you when or if the judge has something specifically, she will ask you. You always treat others with respect. You keep your emotions in check, no eye rolling, no shaking your hands or raising your voice, even if you do get upset. The main thing is just to be just as respectful in your home environment on Zoom as you are in the courtroom.
Well, that's good advice for all of us that are participating, I think. We talked about it a little bit, but Anne-Marie, how do you prepare your clients to communicate with you during the hearing if they're hundreds of miles away?
If it's an adult judge, of course, I give them the option of Zoom chat or texting. Either way is preferable to me, especially since I know that it's private. But, I let that be the parents' option. Some parents are not comfortable using the Zoom chat. So I remind them, if you're going to be using your phone, make sure your phone is on, make sure it's on vibrate or silent, make sure that you're checking it, and make sure that you're responding. When it's a child, it's a little trickier because a lot of times they don't have a phone. If they're in a foster home and they have access to texting, kids are very technologically savvy. So we talk about texting. However, when they're in an institution or a facility, an RTC, something like that, they may not have a cell phone. I prepare ahead of time with a Zoom chat to make sure that they're comfortable using that technology. And I will ask the judge for a breakout time if necessary. But especially with a child, they have to be heard and they have to be comfortable.
Well, in one of our prior webinars, we had a question about whether that chat is actually confidential or not. If an attorney is chatting with their client using Zoom, I can assure you that the court does not have access to that. It is private. And also, I think it would be inappropriate for the judge to try to find that anyway. Now, one of the questions we've already had is a great question, and it's kind of a segue into Leanne's next question here. But I want to ask you this first, Anne-Marie. Is it appropriate for a child and their foster parent to be on the same device at the same time, or if possible, should they each be in separate rooms using separate devices?
I prefer it depends on the age of the child, of course, and the relationship they have with that foster parent. So, but in a general terms, I would prefer for the child to be separate because I want that child to be comfortable in whatever they want to express to the court. I typically opt for the child being in a separate space.
All right. And actually maybe in a separate room with the door closed where they feel like they have some sense of privacy. Is that correct, Anne-Marie?
Yes, Judge.
Okay. Well, we're talking about confidentiality. Leanne, that's a big issue for kids that we have that are in RTCs. How do you ensure, at least on CASA's behalf, that we have that confidentiality for those kids who are placed in congregate care?
I think that can definitely get tricky because, as you said, there's tons of people that, for tons of background noise and distractions. What I have seen that works efficiently is contacting the case manager that's assigned to that kid with that facility, explaining to them they have court coming up, they've expressed that they would like to participate. Can they come to your office? Or is there a separate room or a space that they can go to where they are at, like in that home. And all of the case managers that I've interacted with in this situation have always been very accommodating and saying they can come to my office. I'll make sure that they're ready. When I've had kids actually participate in these hearings that are in an RTC, they are in separate rooms, and I've seen the door actually shut so they can be able to focus solely without all of those distractions that are happening outside of that door.
Well, our kids are sure technologically savvy, absolutely, and a lot of CASA volunteers are as well. But do you think it's a good idea to have a practice run on Zoom with some of your CASA volunteers as well, Leanne?
I do. It's because it's so new. I know when we started doing these, virtual advocacy with COVID, I had never really heard of Zoom. I had heard of Skype and FaceTime. So I asked before we go into a hearing a couple of days before, do you want to do a practice run? Some of my advocates, like Ms. Terry in particular, was already familiar with Zoom and was comfortable with it. So she felt like she was ready to go into the hearing. I've had others that have never utilized Zoom before. So we do a run through just so they can know this is what it's going to look like. And here are the features. Here's how to mute and unmute yourself. Here's also how to stop the video should you need to get up to tend to something that's happening in the home, if you need to take a break, just so we don't have, any mishaps of, I'm sure we've all seen the videos of when Zoom started hearing of a woman that got up and went to the bathroom, and unfortunately everyone could see her. So I definitely do those so we don't have any of those situations.
Well, there certainly are some unique issues that may arise from time to time with courts, and each court may want to try to handle that separately. It may be a good idea beforehand to actually email your court coordinator to see what the judge would like to do in certain situations. We have a lot of bench conferences in an actual courtroom where the attorneys are at the front with the judge speaking privately where no one can hear. It's a little bit more difficult to do that in a virtual setting, but it certainly is possible. If you anticipate having to do that in court, you may want to speak to your court coordinator beforehand about particularly how that judge might like to address those. Conferring at the bench, or actually also a lot of confidential, sensitive client matters that we have that come out, educational and medical records as well. So I want to ask you about that, Dennis, for just a second. What's the best way to confer at the bench, and how do you handle those sensitive issues that clients may have?
You can make a request of the judge. I would suggest that if you feel like you're going to need this, of course, as Anne Marie Smith had previously stated, communication is key, not only amongst the parties, but between the parties and the court. So if you feel like you're going to need that, then inform the court can arrange for it. If it's just something that you need to discuss with another party, you can ask for a breakout room. But if it's something with the court, you're going to have to inform the court, and then they may end up turning off their YouTube feed or making some other similar arrangements, just depending on the judge's preferences.
Well, that's a good answer. There's another question that's come in I want to ask you, Dennis, before we move on. The question is about families and their internet connection. The question is, does the family have to have internet connection to connect to the virtual chat or to Zoom virtually at all? You want to answer that question for us, Dennis?
Sure. There's got to be some form of connectivity. I mean, they can get on through their phone. I think most people probably have a phone, but of course there can be connectivity issues with a phone too. The key is basically just trying it out beforehand, making sure that you do have that whatever location you're in does have good connectivity issues, either on a phone, on a laptop, on a tablet, some device. And so if you try it out beforehand, then you sort of know and you have a good idea as to how things are going to run.
Right. And even today, we've had a little bit of storm activity going on that's caused a little bit of confusion. I was having a hearing either yesterday or the day before where my court reporter in her hometown, the electricity went off. And so we had to let her reboot. So it may be a good idea to not only be connected through Wi-Fi, through your computer, but also have your phone on standby with that Zoom app available as well, so you can use your phone's data to make that connection. Dennis touched on it a little bit, Anne Marie, but do you think it's ever appropriate for you or for an attorney or even a CASA volunteer to ask the judge to stop the video feed because sensitive information is being revealed?
Actually, yes, and I have actually made that request on a couple of occasions, especially in matters that involve children. And sometimes you have issues that are really sensitive. They're sexual in nature, sexual abuse, things like that. The child is not comfortable, having that discussion, knowing that the public could be viewing it. And if it's potentially harmful to the child, I do ask the court to turn the live stream on. I don't like to blindside judges, so typically ahead of the hearing, I will send an email or a text to the court's coordinator and just let them know that, this may be coming up and I'm probably going to be making that request. So the judge is already aware that, this attorney is going to be requesting that the streaming be turned off.
Well, I know there's been discussions in the past amongst judges and attorneys, the fact that we talk in open court about a lot of information that is confidential according to HIPAA and FERPA. We talk about kids' diagnoses, mental health issues, their school grades in an open courtroom. And perhaps as we move back to the open courtrooms, all of us will be more sensitive about that as well. Here's another question for you, Dennis, that's come in. Why is our court now live on YouTube and available for everyone to see? You want to give it a shot?
Why is it? Well, so the theory of open courts actually goes back, it's in I think it's in the Texas Constitution. So courts have always been open to the public. It's just that as technology has advanced, it's basically expanded that audience that it's open to. Traditionally, if you're physically in the courtroom and it's open to the public, probably only those living within that area are going to be able to go drive to the courthouse and sit in on a court hearing. Now it's just with the technology that we have, millions of people can see it because it's on YouTube, but it still comports with that open court theory.
Right. I think that's a great answer and the correct answer as well. One of the questions that we have as we wrap up this section is about kids appearing in court. And we're going to talk a little bit more about that as we move forward, but some judges really are uncomfortable with kids being in the courtroom and hearing everything that's being testified to, especially those younger children. Leanne, let me ask you this question. In lieu of that, if a judge doesn't necessarily want the child to be in Zoom in the hearing, can Zoom still be used and a good way to let the judge and the child have visitation, maybe in a breakout room or at a time completely different than the hearing altogether?
I believe so, and I believe that Zoom has allowed for more of that to kind of happen. I think especially for our youth that aren't placed near us or, placed out of it with extensive driving distance. We've tried the life science in our courtrooms, and sometimes that's a hit or miss. Even sometimes with cell phones, I've had kids placed in facilities that are very rural areas that coverage, via phone is very spotty, but maybe they've got great internet connection out there. So I think the Zoom allows for a breakout session for that child to be able to have that conversation with the judge or just schedule that separately for them.
Very good. Well, I'm really happy with all the questions that are coming in. It's fun to read them, and I think we're hitting a lot of them as we move forward. We're going to switch gears here a bit and talk about, we talked about how the public can have meaningful participation in our hearings now in the convenience of their own home, watching YouTube. Let's talk about how our clients can have meaningful participation in our hearings. So Dennis, logistically, these breakout rooms are great. Can you tell us how attorneys are utilizing them in your court?
Sure. I've seen attorneys use the breakout rooms if there's any last minute negotiations that need to be had. Sometimes I think Leanne Lopez touched on this, maybe you think you have an agreement and then at the last minute it seems to be breaking down. And so you might want to use the breakout rooms for that. If there's some last minute communications that you just need to have with your client because something arose, then you might want to ask really briefly. The key is to use them sparingly and use them effectively and efficiently. You don't want to waste the court's time. You don't want to just unnecessarily delay the court hearings.
Well, it's pretty easy for an attorney in the courtroom to say, Judge, I need just a second to speak with my client privately, and sometimes just turn and whisper in their ear. Now you would have to request an actual breakout room, and the judge maybe twiddling his thumbs while he's waiting. Do you think that using virtual hearings is making it less likely for attorneys to ask to confer with their clients?
I don't think so. As I stated earlier, though, there should be that preparation up front. If we're preparing up front, then it would reduce the likelihood that we would have to use those breakout rooms. But I don't think there's necessarily less use because of any hesitation or any fear that, oh, it may have some effect on the judge or may sway the judge one way or another. I think it's just because of the efforts that have been going in on the front end. I think they just haven't been used as much because they just haven't been as necessary. Now that attorneys are actually doing what they should have been doing.
Let's talk about something else attorneys need to be doing, and that's dealing with witnesses. Lots of times we have witnesses that are going to be coming in and out of our hearings on Zoom, and a lot of folks are only able to participate by phone. I know in our court we've had a lot of people, even parents, that are only able to participate by phone. In fact, this week we had a chief from an Indian tribe that appeared but was not able to appear virtually, but only by telephone. How do you prepare those folks for their testimony when really they have nothing to lose? We can't see them. Goodness, they're just sitting there, maybe in another state on the phone. How do you prepare them to behave themselves when they come into our courtroom?
Well, you tell them it's a lot of the same information. You tell them, look, this is a court proceeding. Their testimony matters, and their behavior and their demeanor on the phone matters. Even though that we can't see them, some of their actions may come across in the tone of voice and how they speak. If there's distractions going on, we're going to be able to hear them on the phone, most likely. So they need to be just as mindful as anybody else that's appearing through video conference about what's occurring. And then, you're just going to have to, sometimes those accommodations where they appear without video, sometimes it's just necessary given the circumstances. But everything that applies to anybody appearing by video still applies to someone who's appearing on the phone.
One of the questions we have as well is sometimes kids are appearing virtually via Zoom, but only they're able to be heard and their video is not able to be seen. Do you have an explanation as to why that may be occurring, Dennis?
I'm sure it could be a variety of factors, either maybe just not familiarity with the technology. It could be connectivity issues. I guess it could be just human error. I'm not sure exactly what it would be, and I can't pinpoint for any specific case. But those are probably my guesses as to what the issues are.
Lots of times it's a day by day factor.
Yes.
Some have attorneys that have great connectivity in their office and they're appearing and looking great. The very next day, they may be sitting there lagging so much that I'm having to tell them, turn off your video so we can have you appear by audio as well. Well, specifically, Dennis, if we have witnesses appearing by phone and they have to read a piece of evidence or there's something to connect them to a piece of evidence, how are you preparing for that beforehand?
That's the work that goes in on the front end. So if there's a witness that that's going to have to appear and they can't appear by video, then you're sending them the exhibits that you anticipate are going to be entered or that there's an agreement to enter. You're reviewing their testimony with them. And then when they're appearing, you're just confirming, asking questions that specifically identify them that only they would know. You do have to tell them you can't read from any items that aren't already admitted as evidence. And so you're just having that discussion with them as you would any other witness to prepare them for their testimony.
Okay. Well, Anne-Marie, we talked about kids and witnesses appearing by phone only. Let's talk about parents. They may have the most trouble doing so. What do you tell your parents who only have phone access?
There's information that have to be, such as exhibits, because we get them typically 3 to 5 days ahead of time. I send those exhibits also to my clients, so they are aware of what those look like, you know, things like that. No surprises there. I also tell them that, you know, we keep in touch, obviously, through text. I make sure that I tell them the other important thing I tell them is that their demeanor or their voice tone should not match the fact that they're wearing pajamas. That, you know, this is a professional setting, it's business, and the demeanor has to match courtroom appearance, because that's what it is. And so, you know, the fact that they are just appearing by phone really should not make a big difference as if they were, you know, appearing in court. It's really just the fact that they can't see you, you can't see them. But again, it's preparation. They have to know what's going on ahead of time. They have to know what the issues are going to be so that they can effectively, you know, also advocate for themselves through how they come off by phone. And that's when their credibility is going to be so much more important, because the judge can't actually see them.
And actually, if you need to confer privately with the client who's a parent who is only appearing by phone, you can still do that in a breakout room as well, correct?
Yes, Judge. And again, I try not to have to use the breakout room because, as you know, the hearings are now very streamlined. It's not process time anymore. So if your hearing is at 10, it is at 10. The next hearing is at 10:30. The courts, you know, set those hearings according to the length and nature of those hearings. And so I think that breakout rooms should be used very sparsely, as Dennis Arriaga mentioned earlier. And we should have already been prepared so that this is just for the little necessities that may come up during the hearing. I don't want to use a breakout room as the time to have been conferring with my client.
So are you going to be able then to text with your clients while you're also speaking and listening and watching the video and keeping your game face on? How's that working out?
So we text furiously. It's like a duck on the lake, on the pond, you know, gliding along, but the feet are moving furiously. So a lot of times that's what's going on too. But again, texting is an option, chatting is an option, paying attention. And, you know, I tell my clients, even if you see me look down, it means I'm texting you. Look at your phone, because I'm sending you a text right now. Sometimes you have to tell the client to shut up. Be quiet right now. You know, you've said enough. Less is more. If you're winning, shut up. So yeah, your text or chat feature can be your best friend during these hearings.
What is your preference, text or chat?
If I'm speaking with the, if I'm communicating with other attorneys, I do the chat. If I'm communicating with my client, I do text, because I don't want in the middle of the hearing for them to be learning how to use chat and we lose valuable time or information. So most people are more comfortable with using text. So if I'm communicating with my clients, I go with text.
Well, Leanne, let's talk to you about this same subject. How do you recommend that your volunteers and their supervisors communicate with each other during hearings?
I also have utilized text more than the chat. Have had some advocates ask me about the chat feature and kind of what it does, but at the same time worry that instead of sending the message to me privately, that it would be sent to everybody. And that may not be necessarily what they want to do. So most of my advocates and we've utilized text during these hearings. And as Anne Marie Smith said, we try to move swiftly as we're doing those. I try to keep it to a minimum as best as possible, try to get every question that they may have answered so I can get right back to the hearing.
What if something unexpected comes up? What do you do then, Leanne?
I have utilized text in those situations as well, especially if it's something we were not made aware of, or, you know, I've had a case where we did not think we had an agreement, but lo and behold, we did as of that morning. So I send a quick text message, kind of ask, you know, how do you feel about this? You know, are you okay? What questions, concerns do you have? And I feel that the text kind of helps as well, because we don't have to always have the breakout session. We can help these hearings move smoothly as possible.
Well, on the other side of the coin, Terry, let me hear from you. Sometimes things are just not going to move smoothly, and that's okay. That things come up in court that are unexpected. Do you think it's appropriate for you to raise your hand perhaps in a hearing and ask the judge, Judge, I need just a second so I can text or communicate with my supervisor so I can get some direction? Would that be appropriate?
I think so, Judge, especially if something comes up that we absolutely were not expecting. And I only have 2 years experience at being a CASA. And so there are things that come up that I'm not exactly sure how to handle as an advocate. And so I would certainly need to talk to my supervisor. I think a chat would be appropriate in that text, but I would not do it unless I felt like it was absolutely necessary.
Well, I don't want to see my daughter texting when I'm talking to her. I want her to see her eyes so she'll pay attention to me. My son as well. I shouldn't be discriminatory against either one of them. I ask them both to look at me when I'm speaking to them. Terry, how do you text while you're also listening to the hearing and letting the judge know you're paying attention? How do you get that done?
Very inconspicuously. And Leanne and I have had to text a few times during hearings, and I'm getting pretty good at holding my eyes up and texting and trying not to let anybody know that that's actually what we're doing. But I don't think really it's a problem if it's something very important, even if people could tell that we were texting. If it's something that's important, then I think that's just fine.
I agree. I think judges are going to be gracious with that. I have not heard a story yet about a judge on Zoom telling somebody to look at them while they're talking to them. So hopefully we don't have that happen. I guess if you're out watching and you've heard about that, you can send us a question in about it. Well, let's switch gears just a little bit, Dennis, and talk about safety. None of us are together, and maybe that increases our safety a bit. We've heard that one of the big benefits of Zoom is that it's safety issues for our child clients who are not having to go to the courthouse. They're maybe more comfortable in their placements, but also they don't have to worry about seeing anyone that they don't want to see or having those emotional triggers. Do you want to talk about that, Dennis?
Sure. I think that the Zoom is beneficial in that regard for the children. There are a lot of courts that when they conduct the CPS hearings, they conduct them with other cases, other divorces, child custody suits, but some of them involve criminal cases. And so you never know who's going to be in the courtroom, in the physical courtroom, whenever you have criminal cases that are occurring. There can be, who knows what they're charged with. Some of them can be pretty egregious. Aside from that, depending on the reasons why the department is involved, if there are serious sexual abuse or physical abuse allegations perpetrated by a parent against one of the children or against the children, it may not be psychologically or emotionally beneficial for those children to be physically in the courtroom as their parents are there also testifying or staring them down or just giving them ugly looks or whatever the case may be. So in that regard, it probably is psychologically, emotionally, and physically safer for the children.
Leanne, do you want to speak to that and maybe about the safety concerns that your volunteers may have as well?
Yes, as Dennis, I think some of those safety concerns, with the Zoom has kind of helped a little bit. I've seen cases where maybe the child wants to participate but is a little scared about facing the parent, or maybe it's a situation where sexual abuse allegations are involved and a parent or the perpetrator may be present, and that makes them a little bit nervous. So I think the Zoom has kind of helped a little bit with that, whether it's they are going to participate with the video on, or maybe it's just at the video. I think that has given them just a little bit more of an opportunity to do that. And of course, I have some kids that in general, the courthouse just seems a little bit more scary, I think, for especially our younger youth. That have maybe been taught of the courthouse, it's a scary place. If you go right in front of the judge, then something bad is going to happen to you. But I think when they're in a comfortable space of, foster home or placement, they feel comfortable. And I think that can almost be empowering for our youth.
Well, that's a great segue into our next section. We're going to talk about the fact that anecdotally, we hear that more kids and parents are participating in hearings. So let's talk about that for a bit. Terry, have you seen an increase in children participation in hearings or also kids visiting with their judges?
I have, Judge. Being in the courtroom, I think, especially for a teenager, is very intimidating to just stand up in front of the judge with people all around you that are answering questions to the judge. And I've noticed, because the case that I'm on right now, we have spent some time in the courtroom and now quite a bit of time on Zoom. And my child specifically has seemed more at ease and more outspoken and outgoing, actually sitting in her own home on Zoom. So I feel like it has helped the kids be a whole lot more at ease in the court setting, being able to be in their home.
And, you know, I've heard of judges talking to kids via Zoom saying, hey, I see something in the background that looks interesting. You know, why don't you tell me about the stuffed animal on your bed or the picture that's hanging on your wall? There's some areas and opportunities for good interaction there as well, wouldn't you say, Terry?
Yes, I think so. And I think just being in a setting that they're familiar with and not having to be in a place that is so stringent and strict, that it's helping them to be a little more outgoing and to speak their mind a little bit more about their feelings.
Well, Anne-Marie, let me hear from you now. Talking about kids in particular, one question, maybe switching gears a bit, is what if you have a child who tells you, I want to speak to you, but I don't want to have my CASA advocate or my CASA supervisor participate in the hearing or the meeting as well? What do you do in those circumstances?
If it's a meeting with the judge, I would have a discussion with the CASA advocate, because typically if a child does not want the CASA, in my experience, it's usually because they know that whatever it is that they're going to be asking the judge, the CASA advocate probably does not support, because of course they go to, you know, what's in the child's best interest. So I would have that discussion first with the CASA advocate so they're not surprised. And then I would let the judge know that, you know, this is the child's preference. It doesn't happen a lot. It happens very infrequently, but it's actually happened with me. If it's a hearing, I let them know that the CASA is going to be in the hearing. I'm not going to ask a CASA not to be in a court hearing. So I lovingly will tell that child that, you know, CASA is here for your best interest. They have to be present. And we talk about all the virtues of why they need to be there so the child is at ease. But for the meeting with the judge, I have asked CASA to excuse themselves.
Well, here's a great question that's come in, and I'm going to ask it of you, Anne-Marie. Boy, you're going to love this one. Do children in care who request to speak to the judge at the hearing or in private have a right to do so? You want to answer that for us, Anne-Marie?
Actually, they do, and it depends on the age of the child as well. So, you know, while a child over 12 absolutely has a right to what they want to see happen and their wishes can be respected, children over the age of 4, they do have a right to speak to the judge as well. And if there's pushback, I file a motion to, you know, ensure that that happens. With children go ahead.
Yeah, that's great. That's the next question. Actually, the second part of that question was, is it acceptable for the judge just to deny that request just because they're being held on Zoom? So if that's happening, what would you do?
I have not actually had a judge deny a request. Every judge that I practiced before, while they do have time limitations, they're usually very accommodating. And, you know, most judges actually want to see the child. They want to see the name to the face and I think it's important for judges to see who this is all about, you know, and to humanize that child. So
for all of our advocates that are out there watching today, what would you give them advice as to if their child really wants to speak to the judge and they're telling their CASA volunteer that, what should that CASA volunteer do?
For me to, okay. So I would want them to bring it to the ad litem's attention that this child wants to speak with the judge. And I think even with children under the age of 3, I mean, an infant I'm not going to bring in to see the court, but even 3-year-olds, they want to see the judge. And they've asked me, you know, is he nice? Is he mean? Is he going to arrest me? They do ask you questions like that, you know? So I think absolutely it should be brought to the ad litem's attention. And absolutely the ad litem should make every effort to make it happen. And if you have an ad litem who refuses, I think you should bring it to the court's attention.
Well, let's talk about parents then, Emery, just briefly. Parents also have some extra opportunities with virtual hearings. Do you want to speak about those?
So, it does remove a lot of barriers for parents, transportation, distance, missing work, fear of being arrested if there's a warrant. Judges have told me that parent participation has actually skyrocketed. I also think that parents are able to appear in a more relaxed, in terms of their, not demeanor so much, but their frame of mind. The emotions aren't running on such high energy because they are in a comfortable space. And we've talked about, the whole privacy and whether or not courts should be open. Yes, courts should be open, but believe it or not, even though there may be 1 million people watching, a lot of parents have told me that they still feel that they have some sense of privacy. They're not facing a courtroom of people listening, perhaps judging, that they're bad parents. And so I think Zoom takes away the jitters for a lot of parents.
Well, let's switch gears and talk about services that need to be provided during hearings. So you can hear the bell going off in the bell tower here at the Mason County Courthouse. It's not on time. It is an hour, but I think our bell is going to only ring about 5 times instead of 1 like it should have. So I'm going to start with you, Dennis, talking about services. How can CPS ensure that services are being provided during this COVID epidemic, and maybe talk about reasonable efforts and what that needs to look like during COVID?
Sure. So, of course, the department is always under the obligation to make reasonable efforts to reunify the child or the children with.
All right. Well, Dennis is lagging a little bit there, it looks like. We might have had some issues. I know that there are storms going on in San Antonio and all that part of Texas. So maybe in a second, we'll have Dennis back. So I'll go ahead and just switch and ask Anne-Marie the same question. How can you ensure that your clients get the services that they need during this COVID epidemic?
I typically, once the service plan has been created, and I try to participate in that to the extent possible, I want to know, what services these providers have to offer with respect to COVID issues. I have found that a lot of the providers have been offering their services via internet. A lot of them have become one-stop shops. So, for example, if they have to have, let's say, domestic violence awareness classes, there may be a component that also offers nurturing parenting or something, like that. If it's a child, a lot of the providers will still come into the home practicing social distancing, but some of them, depending on the therapy, physical therapy, occupational therapy, they also have been providing through internet with participation of the caregiver. So the caregiver actually, they're showing them what to do, and the caregiver is actually performing the function with the child. But I have not had that many clients who were lagging behind in services because they weren't available. And when the instances occur that they are, judges have been accommodating. And of course, Judge, that, we also have clients who had services well before COVID. And of course, COVID has become the go-to. Judges tend to not be as sympathetic to those clients. So beware.
Yeah. If your excuse is the COVID pandemic for missing a service, the judge may ask, well, why did you miss it 5 times prior to the COVID epidemic?
Exactly.
And I think Dennis would say also that the department's become very nimble in trying to get these services provided. And in fact, it's opened up a whole area for us of opportunity. Out here in West Texas, we have to drive a long way to get to services. But in fact, if a service can be provided really well by someone over in Beaumont virtually, heck, that person can provide that service to a kid from Andrews, Texas, 3 or 4 or 500 miles away. So there are some silver linings and some opportunities that hopefully will carry with us after the epidemic is over with, that we can utilize to benefit us all after that. A couple of questions that we have are about how things are going to operate after the epidemic's over. I'm definitely going to get to those during our questions section, if not beforehand. But first I want to ask Terry how her advocacy has changed in her role since we've had virtual hearings as compared to in-person hearings beforehand? Terry?
It's caused me to be very, very organized and to document and be very specific in all my documentation. I also utilize email and texting a whole lot more with school teachers, school counselors, therapists, and determining what type of therapy they're having, how often they've been, have they still been going, and jotting down notes that the therapist tells me, and contacting, being in closer contact with my advisor and supervisor. The main thing with me has been documentation, and communication has had to be more diligent and more often.
Great. Well, that's a good segue into the question I had then for Leanne. Leanne, what are you telling your volunteers about the importance of that documentation while everything's being done virtually?
In general, I've always stressed to my advocates the importance of documentation and have everything entered, into the system. We use Optima in the Lubbock program. And I've always told them, if it's not documented, it essentially didn't happen, especially now with COVID and making sure that these kids are getting their services. Are they doing therapy? Are they still doing it as often? If not, what is the reason for that happening? How is it being done? Because our judges are wanting to know that information. How are they receiving this service? Is it physical therapy or occupational, that maybe they're still going into the home? How are they doing the therapy? And what that looks like, is that still beneficial to the kids? Or is that provider willing to do maybe a combination? With school, our judges had asked, how are they doing in school? And I think for lots of school districts across the state, it looked different. Some did it via packets, some did everything online, some it was maybe a combination of both. And just really having that documentation and those details to let our judges know this is how our kids are getting through this pandemic, and this is how they're still doing school, and this is how they're still getting their services.
Well, when we were having regular hearings a few months back, it seemed pretty often that our CASA supervisor in our court would ask the department for documentation, psychological reports, or drug testing, all sorts of different things. Do you feel like the department's been more efficient here recently since we've been having virtual hearings with that, or are you having to ask more and more for that type of documentation? Leanne, you want to answer that for us?
Sure. So I feel like communication with the department has also been more efficient during this time as well. I feel like the department has always known our CASA advocates are able to get in there and fill those gaps and catch things that maybe the department's not able to. Our department here knows that our program is checking in once a week with our kids. So we are able to provide, hey, this is how they're doing this week. This is what they're struggling with. Those documents, like the psychologicals, I feel like I'm getting those now more often instead of having to consistently request that information from the department. I think they kind of know across the board, we're all going through the same storm, but we're not all in the same boat. And I feel that applies to our kids and our families as well. So they want to also make sure that we're having just that whole wraparound services to make sure they are still getting everything that they need.
Good. Well, there's another silver lining as well. Well, we'll switch gears again now that Dennis is back, and talk about the rule. A lot of you have heard about the rule in your court. There was an example from Region 8 about someone violating the rule. So Dennis, let's talk about the rule. And of course, that we know that means unless you're a party and you are a witness, you may have to be out in that waiting room waiting your turn to testify, which means potentially while you're out there, you could be watching what's going on YouTube. Dennis, can you tell us about that? Maybe what happened in Region 8?
Yes, and this is, I think, unfortunately, one of the disadvantages of having the Zoom hearings. We had a foster father that was going to be called as a witness, and it was a highly contested case, and the rule was invoked, and the instructions for the rule were given by the court, which is not to review the test, not to review the case with anybody, basically not to look at, not to watch the feed, not to resort to any other information on the case. And so the foster father was put under the rule. And then when the court reconvened after the hearing, which the foster father was not called a witness for, it was discovered that he had, in fact, been watching the YouTube feed, and he admitted it himself, and he was heard saying that he was watching it because he got frustrated. And it's a very serious issue. And I don't know if there's any way to stop it, because it's not like in your physical courtroom where you can see the individual peeking in through the door or listening up against the door. So, it's much harder to catch someone doing that.
Well, would it be a good idea to ask every witness who's under the rule as the very first question, have you been watching the YouTube?
Absolutely. Absolutely. Yeah. I mean, I think that's unfortunately something that we're going to have to do now. Now, of course, they can lie, but that opens up a whole nother set of issues for them. But I think that is entirely an appropriate first question for them, and to make sure that you have them on record indicating whether or not that they have violated the rule.
Very good. Well, Leanne, sometimes we need to interrupt the judge when he's talking, or lawyers when they're talking. How do you do that politely when we're on a virtual hearing?
I've actually just politely raised my hand up high enough where the judge can see that I have a question. I think sometimes, like with the Zoom, sometimes feed can be delayed, that you don't know if someone's done speaking. So that makes it kind of easy to maybe sometimes speak over each other. So I've just simply raised my hand, and the judge called on me and says, do you have a question? And I feel like it's really kind of the best way, because in our courtrooms, when it comes to the chat, it's the court coordinators that are monitoring that. But I think that's still also a great option to utilize should you need to ask, just to interrupt or ask a question for anything.
Well, I think it's appropriate to say, Judge, we're having a hard time hearing you, or we didn't understand your question. Typically, it's my court reporter that will unmute herself and tell me that on behalf of everyone else. But if that's not happening, I think that would be totally appropriate, and no judge would be upset if you had to come on and say, Judge, we can't hear you, or Judge, you're going to have to ask that question again. I don't think any of the judges in Texas would have a problem with that. Anne-Marie, let's talk about another subject that, that I know is near and dear to your heart. How do you prepare for the possibility of your client's spotty internet connection? Maybe we should have asked Dennis that question, but we'll let you have it.
And I actually had my own very spotty internet connection earlier today. And so usually, unless there's an emergency and your entire subdivision has lost power, as mine did a few minutes before joining, clients know ahead of time, what kind of internet reliability they have because of where they live. And so they may have to plan ahead, to go somewhere where the service is better. If they can't, I advise them to just appear anyway, and we'll deal with it as we get to that point. Most judges ahead of time I know Judge McClanahan usually ahead of time will say to the participants, I'm glad you were able to appear. If we lose you, don't worry, just come back in and I'll let you in. So she lets that be known. Or I may urge them to just use the phone. Zoom is good because when I have a parent, I'm always mindful of that parent's credibility and demeanor and being able to impress the judge with, appearances and things like that. But of course, spotty internet does happen. And I just tell them, listen, if we lose you, just try to get back in. If you can't get back in through Zoom, use your telephone.
Well, I'm not surprised to hear that Judge McClanahan has a good piece of advice for me and all the other judges in Texas. I've written that down, and I think that's a really good idea, because it could be traumatic for a parent, I think, if they were right in the middle of their testimony and lost service or froze up. So I think that may be a good idea for all judges in Texas to give in our opening admonishments that, hey, nothing is perfect. This is an unusual time, and if it happens, log back in and we'll go from there. If you weren't in McClanahan's court and that happened, what would you do at that point, Anne-Marie? What would you ask for the judge to do?
I would ask the judge to allow my client to come back in. Most judges, because they're on a time constraint, they may want to continue. But I've had judges agree that, we'll pass this portion of it and let's talk about the dad, or let's talk about the child, to give your client time to get back in. I have found that judges are extremely accommodating, and maybe it's because now we have 1 million YouTubers watching, but judges are pretty nice and pretty accommodating, and they allow clients back in, and there's nothing we can do if we lose internet because it's out of our control anyway.
Well, Leanne, you have some great judges up there in your area as well. What is the process that you've seen them take if someone loses an internet connection or is having spotty service?
Our judges have definitely given, I think, everybody in the Zoom rooms a little bit of grace and understand that maybe signals drop, or maybe you just can't figure out some of the features like the mute or unmute. And I've had some that we can hear the audio, but we can't see their face, or maybe vice versa, and they just can't really figure out why that's happening. So like I said, they've been very just graceful and kind of saying, go ahead, log out, log back in, see if that helps. If we're fixing to start a hearing, if it's a parent that's having those struggles, they have both just kind of said, we'll go on to the next hearing, give this parent or attorney or CASA, whoever it might be, a chance to maybe get some better coverage, maybe move to a different area, or help find someone to kind of help you figure out those features so they can still participate in that hearing.
Well, I'll give you all a little bit of insider information. When we started with Zoom hearings, the judge was able to take people off mute and put them back on mute, kind of at the judge's discretion. But we've had an update to Zoom, and now the judge sometimes cannot take people off of mute. So you may want to remember that as you're moving forward, and be ready for that on your phone. I know it's kind of awkward to take yourself off of mute, so that may be a little bit of a practical tip as we move forward. We have just a few more minutes here with regards to some questions for our panel, and I want to ask our next question then to you, Dennis. Let's say that the hearing has concluded, but we still need to get that order signed. Lots of times we would do that in the hall after the hearings as well. How are we doing that now, Dennis, where we can't catch everyone in the hall?
Well, if, going back to that preparation at the beginning of the case, so if we haven't been able to reach an agreement and secure signatures for the order in that regard, then after the hearing, what we've done is we've implemented some policies to try to secure those orders as soon as possible. We send the orders out immediately after the hearing. I say immediately, it should occur the same day. Sometimes it occurs the next day. And then we just try to get as many signatures back as we can. Of course, the alternative options are, I know that some courts have instituted standing orders stating that if not everybody has signed the order within a certain amount of time, then the version that was initially circulated is the version that's going to be signed by the court, even without signatures. And then sometimes the judges have set timelines, like everybody has to sign it within a certain, just standing order that orders all the attorneys to sign and all the parties to sign within 3 days or 5 days or something like that. And if all else fails, then we file a motion to enter, and we'll just have to have a quick hearing if we haven't secured some of those signatures.
Here's another practice tip. Back when I was a child protection court judge, I operated in 4 different CPS regions. Some of them required everyone to sign those orders, but in some regions in Texas, nobody signs orders but the judge. So that may be something that we need to rethink as well. Well, let's go ahead and see what questions that we've had during our conversation. Just as a reminder, we're going to try to answer all these questions here, but any questions that we don't answer, we're going to do our very best to answer afterwards by email. If you submitted your question anonymously, of course, we can't do that, but we're going to do our best to get all these questions answered before we wrap things up. Anne-Marie, I want to ask you this question first. It came in, I think, before we talked about it, and we did talk about it a little bit, but as an attorney who represents parents, but also as an attorney who represents kids wanting to have those parents do what they need to do, this question may be good for you. How do you suggest handling a parent who is using the pandemic as an excuse not to complete their services?
So there are judges who say things like you can lose your job or you can lose your child. And I have a come to Jesus talk in the beginning, in the middle, and in the end. And so at the beginning of the case, I let them know that the pandemic notwithstanding, You are expected and required to do your services. They are an order of the court. Some judges may hold you in contempt for not doing your services, and most judges will terminate your parental rights if you do not complete your services. So it's sort of like a no excuses bar at this point. I found that with some of our parents, if you give them a little latitude, they're going to walk right through that door and knock the walls down even. And so I am very hardcore when it comes to representing parent clients, because I tell them we're in this to get our kids back. And it's hard work, and it's harder work because there is a pandemic. And if you're not willing to do that work, roll your sleeves up, and anybody out there who knows me knows that is my approach, then here's a piece of paper, and the title of it says Mother's Affidavit of Voluntary Relinquishment. You probably should sign that now, because we're here to put the work in, and we're not here to make excuses. And if you want your children back, it's work, and it's even harder work. And quite frankly, judges are really impressed with parents who are going out and doing it in the face of this pandemic, because there are parents who are doing their services. They're finding ways, they're getting into treatment programs, they're doing what they have to do. And those are the parents who succeed.
Well, I think that's a great point. And I know we've had a couple of parents in our court that have been very successful, and you can just see the smile on their faces when they're telling us, even through the computer, how much they've gotten done even during the pandemic. Well, Dennis, while you were out taking your break there a little bit earlier, we kind of skipped a couple of questions for you, but one of them has come back in as a question. So I'll ask you, here's the question. There are a lot of services that are not available in our area due to COVID-19 restrictions. What accommodations have been made in other areas that are struggling with this hurdle as well? You want to answer that for us, Dennis?
Sure. There are services that are provided. If they're not provided in person, they're provided virtually. I know a lot of parents are completing their services online, either through video conference, or sometimes it's just, observing some material and maybe taking some review questions about it. And so there are some accommodations that are being made, and if all else fails and there's just not that service provider anywhere and it's not able to be secured, that's, I think, why the Texas Supreme Court instituted its orders and authorized an extension in these cases, because there is, I think, somewhat of an understanding that there might be a possibility that some services may not be able to be completed. And that's what the extension is for, is to provide those parents maybe a little bit more time until those contractors start providing those services again.
Well, the next question I have is for you, Leanne, but I want to let you follow up on what Dennis just said. I'm not sure that we've given you an adequate amount of time to talk about services and parent services and maybe services for kids as well. Do you want to speak to that and how things are going in your area?
Yes, in our area, I feel like our judges are understanding that there are just some services that aren't able to happen because of COVID, whether it's that the provider is not open to doing those, or maybe it's just they don't feel comfortable, or they're just so booked it's hard to get them in if they're doing things virtually. So I feel like our court understands that, but they also continue to let these parents know, if it's a provider that says, hey, I'm doing things virtually, and parents say, I've called, but they haven't called me back, well, then you need to try to keep calling and document for yourself what day, what time are you calling? Did you leave a voicemail? Because the judges are still letting them know we are still in a timeline, and we don't want this to go any longer, continue to delay permanency for their children, whether that means, they get to come back to them or there's another scenario that happens.
Well, Terry, these next set of questions are for you. I have some volunteers that are really very, very good about encouraging parents to get their services done. In lieu of all that we've talked about here today and the limited services that we may have because of COVID, or even the expanded services that we may have because of COVID, what can a CASA volunteer do to encourage and help parents work through service plans?
I think just to keep in constant contact with them you know, maybe on a weekly basis, say, what have you done this week? What services have you completed? Where can I help? Is there someone I can call? Is there some place I can drive you to? Or is there a way that I can make a communication with someone that you've not been able to get a hold of? My parents have been the most successful when when they have a CASA who is on their side, tends to be on their side, and makes the effort to try to help them complete those services. Mainly just encouragement and offer to help in any way that you can.
Well, I promise you that I've had several cases where the children return to the parents for one reason, and it was the CASA volunteer. And so we certainly know that the amazing ability that our volunteers have to reunite families, to get termination when that's appropriate. And so as parents are stepping up, the department's stepping up, attorneys are stepping up, we know that our CASA volunteers across the state are going to do so as well. Well, let me follow up that question, Terry, with this question then. What can CASA volunteers that are watching do to help kids get the services that they need during this pandemic?
I think mainly, again, probably communication and documentation, contacting and seeing what changes need to be made as far as scheduling, or if things need to be done, if rescheduling needs to be done, things need to be taking place in a different place, or if it's a group therapy and you can no longer be in a group, is there a way we can schedule it privately, or maybe even do therapy through Zoom or virtually? I just think mainly communication and documentation, and doing whatever you can do to make sure that those services are being taken care of, even if it is you providing the transportation, or being in constant contact with the therapist to see how you can work out scheduling differences. Mainly just documentation, communication again. Well,
I kind of think what you're saying is the squeaky wheel gets the grease a little bit, and I know a lot of squeaky wheel CASA volunteers.
Exactly. One of those, right, Leanne?
So, Leanne, did you want to follow up on that? I have another question for you, but I thought you might want to say something else about kid services.
Yes, just to echo what Terry said, be that squeaky wheel. I've had a lot that, they acknowledge I'm the squeaky wheel, and I'm going to make sure that I get the grace for my kid and their services, especially in light of this pandemic. Everything kind of came to a halt for several months, but that doesn't mean that our kids that need trauma therapy, our kids that need physical or occupational therapy, that doesn't mean that comes to a halt for them as well. They are still going to need those.
Well, specifically, here's a question for you, Leanne. What can a CASA do if a placement does not have internet or says that they have no ability to facilitate visual communication with their child and their CASA volunteer?
I have actually come across that during this time, and it was kind of one of those of, I tried to ask, do you have Zoom? Do you have Skype, FaceTime? Do you have the Google Duo? Really every video chatting platform that I could think of, I offer that as options, but the placement was just not familiar with those, wasn't very technology savvy. She had said that when it came to Zoom, that it was one of those of, she had tried it, but she just could not get the technology work. So I think maybe asking for, maybe a couple of pictures. Hey, can you send me the picture of the kids to see what they're doing? We were, like I said, we were doing weekly contact with our kids, and just making sure we are keeping that consistent contact of, hey, can I see what the kids are doing today? I think that that's another way to still kind of ensure the safety of our children if video conferencing or an internet is an issue.
And also, Dennis, we can ask the judge to make the department get that connectivity available, correct?
Correct. I mean, if there's always options. I know that with the pandemic that travel and going into groups is a little bit restricted, but just exploring other options, for the caseworkers, maybe it is possible for you to come into one of the local offices and utilize, you'll have a better connectivity attempting it through the office. That might be an option for an advocate. Maybe there's some relative that you can go to that their house isn't packed with people, but you can still go there or something like that. That's always an option.
Just a reminder, thanks to someone from Tarrant County who said, in Tarrant County, CASA volunteers can't provide transportation. We know that that varies across the state. So thanks for that shout out there. Let me ask you these questions, Anne Marie. First of all, this is a good question. When it comes to services during COVID, what is the court's mindset, or what are our general thoughts about your analysis examinations, UAs for parents?
So parents are still having to go to these, to get these tests done. They're still being ordered to go to hair follicles. I've not experienced any, relaxing of the rules from any of the courts. They're still expected to do that. And clients have said to me, I couldn't go because they weren't offering services. And I check myself because I don't want a client to be caught, in a fib. So I have not found any of these services, any of these providers to not be open. They are still open. They are still doing those tests. And that's something I make aware to my clients so that they go, because as we all know, if you miss a test, it's a presumed positive result. So we don't want that to happen.
Even during COVID. Well, we've got a couple of questions left. One of them is, if you need a translator, is that handled differently on Zoom? I'm not going to take a lot of time to answer that question, but I'll tell you that, yes, that is a silver lining for the courts. We have Zoom translators in Austin that work for the Supreme Court of Texas that are available to us now by Zoom. We can actually have 4 or 5 or 6 different languages all being translated at the same time via Zoom. And it's done in a way where only the person who needs to hear their testimony in their language can do so. It's amazing. If your judge doesn't know about that, CASA volunteers, supervisors, I encourage you to tell your judge that Zoom has a great translation service and it's free, and we can use those great translators that we have in Austin. Here's the last question before we end here today. This is a long question, but I'm going to read it. We are from a small rural community where our children have to be in RTCs that are maybe even sometimes over 150 miles away. We're all familiar with that. It's difficult to acquire transportation to and from court. Here's the best question. Is there any way, once things are back to normal, that we can still use Zoom to have our children's voices heard in court? I think the answer to that question is a resounding yes. I think judges have learned, CASA supervisors, CASA volunteers, the department, parents, attorneys, everyone has figured out that this is a great way for us to have kids appear in court, parents appear in court, and our hope is that as we move back to normal court hearings, we'll be able to take the best part of these virtual hearings and use them as we move forward. Well, as we end here today, I want to thank our great panelists for being here with us, even under unusual circumstances. Like I just said, my guess is that we're going to be using Zoom and its technology for a long time to come, and hopefully you've learned something about the skills that will help you do so. Thanks, everyone.